2 on the record. My co-counsel will make submission for the claimant, and Mr. Tan will respond for the respondent. The parties will then engage in a round of rebuttal. I will speak first for 16 minutes, reserving a further minute for rebuttal. Ms. Nee will speak for 12 minutes, and she too reserves a further minute for rebuttal. If this tribunal is agreeable with this order, I shall proceed with my submissions. Thank you. Members of the tribunal, the dispute at its core is about the respondent's failure to uphold reasonable expectations that arose out of his contractual relationship with my client being the only buyer with a contract at the time of breach. Now, on 4th November 2014, my client made an order for 10,000 bottles of the respondent's Diamond Mata Welton wine, something which is guaranteed to it under the contract. However, citing bad weather conditions leading to shortages, the respondent refused to deliver in full. However, a month later, in December 2014, the respondent contracted with an entirely new customer, Super Wines. And they did so for that exact number of bottles which was not delivered to my client. In doing so, the respondent put it out of its reach to fulfill its contractual obligations owed to my client, and it is against this backdrop of events that I make 3 submissions.
Maybe you can take us straight to the contractual obligation.
Certainly, Mr. Arbitrator. If you turn with me to page 9 of the record, page 9 of the record is where we can find a framework agreement between the parties. And at page 9, Article 2, there we see the obligations of the seller, and they agree to sell annually to the buyer up to 10,000 bottles of wine. For the purpose of this dispute, the respondent has not contested the breach, and we are now making a claim for the profits which it made in its sales to Super Wines, a third party.
Sorry, if the respondent is not contesting the breach, what are they contesting?
They're contesting the measure of damages, Mr. Arbitrator, as well as whether or not document disclosure should be granted. Now, turning to my first submission, which is that my client is entitled to the respondent's profits it made from its sale to Super Wines, this tribunal can order such a claim because this remedy is awardable under Article 74 of the CISG. Article 74 defines damages as a sum equal to the loss of the innocent party. Now, we accept that at first blush, this article does not make any mention for a claim for profits. However, awarding such a claim under Article 74 is not a novel remedy under the CISG. Previous tribunals adjudicating on the CISG have indeed awarded such a claim under Article 74. And one example is the 2007 Stockholm Chamber of Commerce decision in the Precious Census case. While the case involved a breach of confidentiality agreement, the tribunal granted a claim for disgorgement because the aggrieved party's loss was difficult to quantify. And that was a crucial factor resulting in the tribunal eventually holding that a disgorgement claim is in order under Article 74.
Are there any other decisions that have done this?
Mr. Arbitrator, this is will be the only decision under the CISG.
But maybe they just got it wrong, right? Because Article 74 says loss explicitly, so it might be that one tribunal is a deviant tribunal of sorts, but that's no reason for us to follow the case.
Certainly, Mr. Arbitrator, we note that that might be the only decision. However, numerous commentators, including Professor Swenzer, the late Professor Skletchram, and most recently Professor Niles Smith-Arends, have all argued in favour for a claim under Article 74. And we note that Mr. Arbitrator pointed out that the word loss makes no mention of a claim for profits. However, Professor Smith-Arends pointed out that the drafting history of Article 74 would show that a claim for the breaching party's profit was not discussed back in 1980 only because a gains-based remedy was not prevalent in most national jurisdictions 30 years ago. However, the situation is vastly different today. And Professor Swenzer pointed out that in Germany, England, and Canada, developments have since occurred where a disgorgement claim is a remedy for a breach of contract. And therefore, even if Article 74 does not expressly contemplate such a claim, the lack of a reference does not bar this tribunal from considering this measure as a form of remedy. And we say that the only question, therefore, before this tribunal is whether it is appropriate to do so on the facts.
Is there a legit way of interpreting the CISG? Like, even though it wasn't contemplated at the time it was drafted?
Madam Arbitrator, it would certainly be a legitimate way to interpret the CISG because there was no discussion on whether a claim for disgorgement should be allowed, and the silence on this matter should not be taken as exclusion.
No, I would understand that if you were talking about a contract, but the CISG itself is an international treaty, right? And when you look at agreements between states, you can't assume they agreed to what they didn't discuss. It's slightly different from looking at commercial relationships.
Certainly, Mr. Arbitrator. However, under the CISG, Article 7.1 does provide, Article 7.1 can be found at tab 4 of the bundle. Article 7.1 states that in interpreting this convention, regard is to be had to its international character.
Doesn't that work against you?
Mr. Arbitrator, as pointed out by Professor Strenzer, the international developments today do show that a disgorgement as a remedy is indeed available under contract, under a breach of contract, but of course confined to exceptional circumstances. And one of the main requirements as stated in the Pressure Census decision is that the loss must be difficult to quantify. And here we say that our loss is indeed difficult to quantify for two main reasons. First, at page 54 of the record, paragraph 13, the tribunal clarified that it would be extremely difficult to calculate my client's actual loss or profits. And second, more importantly, it is impossible to ascertain the actual price and quantity of wines that could have been sold because my client sells the respondent's wine exclusively through a pre-order scheme. This pre-order scheme can be found on the next page, page 53, paragraph 6. Now, this is the pre-order scheme that my client sells the respondent's wines exclusively through. And if I can explain how this scheme works. Customers can choose between two different schemes available, one of which they undertake to pay a higher price, and in return my client guarantees a higher percentage of their pre-orders. Second, and more importantly, customers are obliged to take only between 70 to 80% of their pre-ordered wines should the eventual selling price be within the stipulated price when they make the pre-order. And lastly, they are not obliged to take any wine at all should the eventual selling price be out of the range of the stipulated price when they make this pre-order. And we say that this pre-order scheme is complex and it leads to uncertainty on two levels, in that both the price and quantity which my client could eventually have sold the wine for are unknown to my client.
Let me just take you back to the earlier part of the submission. You said early on that the difficulty of quantifying loss is a crucial factor. Later on you say only under exceptional circumstances. Does the respondent agree that that is the case?
Ms. Wong?
Presently, the respondent is disputing these elements of the test. We are suggesting that there should be an additional element of misconduct on the part of the respondent before this exceptional remedy should be granted.
Alright, thank you. What do you say again?
We say that there's indeed misconduct, so to speak, on the respondent's part. And if I can refer this tribunal to now page 11 of the record. Page 11 of the record will show us that the respondent knew of the bad harvest and the impending shortfall, yet they went ahead to contract with Super Wines, a completely new customer. Now at page 11, the first paragraph, the second line. This year's harvest was made particularly difficult by the very wet second half of August. And the next line, since the weather conditions did not improve, the harvest was one of the most difficult in recent memory. This shows that the respondent was indeed aware of the impending shortfall and that it was not going to be able to deliver in full to its customer. However, it went out of its way to contract an entirely new customer, Super Wine, a customer which it never had any previous dealings with. Crucially, my client placed our order for 10,000 bottles, guaranteed to be under the contract, on 4th November 2014.
I'm looking at this statement and it says that they offered to distribute the available quantity pro rata to all of their customers. So what was your reply to that?
Mr. Arbitrator, we rejected a claim, an offer to distribute the wine on pro rata basis. This will be found in the letter by on page 14, signed by Mr. Friedenstreich, who was our Chief Operations Officer during the time when this dispute occurred. At the third paragraph, you understand that we are in particular not willing to give up some of our bottles for the delivery to our biggest competitor, Super Wines. In fact, we insisted on 10,000 bottles of wine guaranteed to us under our contract. And we had done so because we were the only party when the breach occurred in December that the respondent owed a contractual obligation to.
Sorry, why is this misconduct? Why is it just not an efficient breach of contract?
Madam Arbitrator, the efficient breach doctrine is we know to be a common law doctrine that's practiced in the UK. However, under the CISG, we place great emphasis on the doctrine of pacta sunt servanda, and promises must be kept. And because of that, we say that efficient breach doctrine has no application on our present facts. Crucially, we note that we are not asking the respondent not to make delivery to any of his long-standing customer. And we also note that there is no exclusivity agreement or contract. However, what we are suggesting is that the respondent went out of its way to contract an entirely new customer despite knowing of a shortfall, something which they should not have done with the knowledge that they are not going to be able to deliver in full.
Is it against base remedy also?
Mr. Arbitrator, however, might be practiced in many common law countries. However, civil law countries, including Austria and France, have also adopted these measures in recent cases, domestic cases, not applicable to the CISG, I'm afraid.
So efficient breach is not available on the
It will not appear not to be available, and one of the strongest case for it will be Article 45 of the CISG, which insists on specific performance in the case of a contractual breach. And because of that, an efficient breach giving the damages is not something which is applicable under the CISG, and the tribunal should be slow to grant the respondent the benefit of the doubt in this case. Now, I'll now quickly turn to my second submission, which is on our claim for document disclosure.
Sorry, I just want to check something. How did you know at the time you wrote the letter of 2nd December 2014 that the respondents had contracted with Super Wines?
Mr. Arbitrator, they only contracted with Super Wines on 2nd December.
So, sorry, when you wrote the letter, you said you're not willing to give up your bottles for the delivery to your biggest competitor, Super Wines. I'm looking at page 14.
Yes.
How did you know this?
Because this was communicated to us, we actually saw this based on certain industry journal, and these industry can be found at page 12 of the record.
Okay.
These are certain industry journals for the high-end wine, and that's where we note that there was a new player in the market, Super Wines. However, we did make our order on 25th November 2014, which was earlier than when they had entered into a contract with Super Wines. And we know that to be on the facts on the 4th December. Therefore, we say
This all looks like rumors. There's something. I don't see any definitive statements that there has been a contract.
Mr. Arbitrator, certainly there was no, we do not know the final date in which the contract was concluded. However, based on the facts at page 56 of the record, paragraph 22, the tribunal clarified that Mr. Barello, who is the CEO of Super Wines, submitted his offer on 25th November. So, based on that, yes, and this offer was duly accepted by Mr. Weinbauer, respondent CEO, a week later on 2nd December. So indeed the contract was concluded, however we do not know much the exact date between this week. In any case, it will be earlier than when we submitted our offer. Now, in the interest of time, I move quickly to my second submission on the issue of document disclosure. We are requesting for communications between the respondent and Super Wines between 1st January 2014 to 14 July 2015, in particular documents relating to the quantity and price of wine sold to Super Wines. And the crux of this procedural dispute lies very much in the interpretation of the term "no discovery shall be allowed." And this term may be found at page 9 of the record. At page 9, under Article 20, at the 6th line of the paragraph, it states that the proceeding shall be conducted in a fast and cost-efficient way, and the parties agree that no discovery shall be allowed. Although the words might appear to be unambiguous, it must be noted that the parties come from different legal backgrounds, and the term discovery is often used by common law countries. Therefore, the tribunal must consider the intentions of the party at the time of contracting so as to interpret the clause. And this is supported by Article 8.1 of the CISG. Article 8.1 provides that a term must be interpreted according to the maker's intention. If if the counterparty could not have been, ought to have been aware or known of the parties, of the maker's intention. Here my client was the maker of the term, and it intended only to exclude extensive form of document disclosure and not all forms of document disclosure. Mr. Friedrich Streich, who was my client's former COO, included the term after receiving advice from his brother, a lawyer working in an MNC, that this particular no discovery shall be allowed term was meant to exclude only extensive US-style discovery.
Sorry, the test you just cited, is that subjective or objective?
Subjective test, Mr. Arbitrator. And that's the first port of call for this tribunal under the CISG. And now, the maker's intention, my client's intention is that we intended to only exclude extensive document disclosure that will incur high legal costs, such as the US-style discovery.
No, but that troubles me, because if you say it's a subjective test, and we have to take your word for it, then you can come here and tell us you intended anything from the term, and we'd be obliged to believe you. That can't be the case, right? So how do we tell what your intention was?
Mr. Arbitrator, I apologize if I was not clear, but the test also stipulates that the maker's intention will only be taken if the counterparty known or could not have been aware of the maker's intention. And here, we say that the respondent was clearly aware of our intention. I see that my time is running out. It's up. If I could have 1 minute to address this tribunal on the intention.
Should you show us where
Sure.
you say they knew of the intention?
At page 33 of the record, Mr. Arbitrator. At page 33 of the record, this is a letter sent by the respondents. Sorry, not page 33, apologies, page 31. This is a witness statement by Mr. Weinbauer, who was the respondent CEO at the time of contracting. Now, in the last paragraph, the third line of the second last paragraph, if you consider I understood the clause to exclude all types of requests for document which go beyond requests for particular documents in very specific circumstances. And this is a concession by the respondent that their CEO knew the term excluded all other types of document disclosure which went beyond specific requests of document disclosure. And therefore we say that the dispute is not so much about whether this tribunal has the power to order disclosure, because the party's intention was that it was meant to exclude the extensive discovery. And the dispute is certainly about whether or not the claimant's request is unduly wide. And to that,
You're talking about communications with supervisors.
yes, Mr. Arbitrator.
Supervisor party.
Supervisor is not a party to this contract, Mr.
Do they have
Arbitrator.
rights?
Yes, we note that it is the respondent's case that they owed an implied confidentiality agreement with Superwines. How,
If they're not here and they have rights, what do we do?
Mr. Arbitrator, the rights of Superwines would not be infringed if this tribunal ordered document disclosure, because there are various measures this tribunal can take to protect the confidentiality of Superwines, such as redacting of documents, making sure the documents are only for the attorney's eyes, or in the most extreme circumstances, only this tribunal has sight of those documents that we are requesting, because we need this document to calculate the price in which the wines was sold to the Superwines. Therefore, confidentiality should not be a concern for this tribunal.
But you just explain one last thing to me. Taking you back to page 31.
Certainly, Mr. Arbitrator.
You see, you're saying that the first sentence is a concession. But if you look at the next sentence, it says, given that the law of Mediterranean allows only requests for particular documents, I had no doubt that such a provision would also be possible. And the use of the word also seems to suggest that this person was thinking of something different from the laws of Mediterranean, right? It seems to suggest he was thinking of excluding all types of requests for documents. What do you say to that?
Mr. Arbitrator, certainly we note that Mr. Weinbauer is no longer the respondent, and we are unable to clarify what he meant when he wrote those two statements.
Yeah.
However, that is not what our case rests upon, because the respondent's subsequent conduct would also show that they were aware of this intention. If I could have just 1 last minute to show Mr. Arbitrator
Two
this.
sentences.
In their subsequent conduct, the respondent, in accepting the Vienna rules, stated that document disclosure should be excluded. If the original clause already excluded document disclosure, there was no need for them to now qualify their acceptance of the Vienna rules. And subsequent conduct is relevant under Article 8.3 of the CISG. If I will no further assistance, this concludes my submissions.
Thank you.
is Wong Yan Yi, and together with my co-counsel, Mr. Jeremy Tan, we appear on behalf of the respondents, Vino Veritas Limited. I'll be addressing this tribunal for the next 15 minutes, and I respectfully reserve a further 1 minute for my sir rebuttal. I'll be addressing this tribunal on two main issues as laid out by the claimant. First, whether the claimant is entitled to a disgorgement of the respondent's profits, and second, whether the claimant's request for document disclosure can and should be ordered by this tribunal. Members of the tribunal, throughout this dispute, the claimants have defied market practice and have refused the respondent's attempts at amicable dispute resolution. The claimant now seeks to punish the respondents for the bottles of wine it itself could not obtain. They not only sought an injunction from the Mediterranean High Court, but then proceeded to sit on this injunction for the next 7 months without instituting any proceedings. Despite obtaining substitute wines from Big Nobilia, they now still seek a disgorgement of the respondents' profits and further request for wide-ranging document disclosure, which places an unreasonable burden on the respondents.
You say unreasonable, but they had a contract with you, right?
Mr. Arbitrator, regarding the unreasonableness of behavior, the contract provided for between both parties did not provide for a disgorgement of profits. And because of that, the respondents in this case are suggesting that a disgorgement would be unreasonable in the circumstances. It is against this backdrop that the respondents have three main submissions to make. First, that a disgorgement of profits is not available under Article 74 of the CISG. Second, that even if this remedy is available to the claimant, this tribunal should not order it on the present facts. And lastly, that the claimant's request for document disclosure is overly wide. Turning to my first submission, Article 74 of the CISG does not encompass a disgorgement of profits. The express wording of Article 74 is that damages for breach of contract by one party consists of a sum equal to the loss suffered as a consequence of the breach. And this express wording pegs the damages that a claimant would receive due to a breach to the losses that they prove. This makes clear that the damages calculated must be made with reference to the losses of the claimants and not the profits of the respondents. This interpretation is further supported by CISG Advisory Council Opinion Number 6, which states further that punitive damages with reference to the gains of a breaching party would be contrary to the principles of Article 74. The claimant in this case has attempted to cloak their disgorgement of profits as a gains-based measure of their losses. However, they have not shown a causal connection between the profit they would have obtained from the contract and the profit that the respondent had obtained from Superwines, which is a third party to this dispute. In this case, the profits that the claimant would have obtained if the contract had been duly performed is different from the profits that the respondent has obtained from Superwines. This is because the respondents and the claimants occupy a very different position in the market. The respondents in this case are producers of wine, and they start at the beginning of the chain in the market of the wine industry, whereas the claimants are resellers in the collector's market. And this presents very different positions in the market, for which the claimant cannot say the respondents' profits will be equivalent to their losses.
No, but you're talking about one term, right? You're saying you can't say loss of profit will equate. But what your submission was that there was no causal connection. And the causal connection seems quite clear to me, right? If you hadn't sold more bottles to Superwines, you would have more bottles to sell to your other customers, including the claimants. So when you sold to Superwines, you caused a loss to them.
Mr. Arbitrator, it is true that if we had not sold the wine to Superwines, then perhaps the claimants could have obtained a greater percentage. But considering the fact that market practice is a pro rata allocation, and in this case the respondent's allocation is between 40 to 60%, the claimants in this case already obtained 57% of their order, and this is already on the high end of the spectrum.
Is it market practice to enter into framework agreement?
It is not, Madam Arbitrator, it is not market
So
practice.
clearly anything that comes out of this agreement, you can't really peg it to market practice, right? Because your agreement itself is quite different from market
You would
practice.
have reached the agreement even if just by a smaller amount, so they'd still have lost.
Members of the tribunal, the respondents in this case are not suggesting that we did not breach this agreement. In fact, for the expediency of these proceedings, we have admitted and assumed that there is breach. But rather, we are simply requesting that this tribunal consider a disgorgement of profits is not the adequate remedy in the present case.
Okay, I'm sorry, I'm just curious about something. When they ask for disgorgement of profits, they are looking at simply the amount you sold to the amount you earned from selling to superwines. Right? Can you give me the elements of their losses? Not the quantum. I accept that's difficult, just the elements.
In this case, the claimant's losses would be how much they would have sold the bottles delivered to them to their customers instead,
Anything else?
as well as any loss of reputation they may have sustained if they can show that there's reasonable certainty that this loss existed.
Okay.
The
But
rest-
assuming we accept that they've lost both of these things, wouldn't the loss of profits, sorry, wouldn't their loss actually be higher than the profits you earned?
Mr. Arbitrator, there is a possibility that their profits may have been higher than the profits that we gained.
And if that's the case, then it seems like they're actually just asking for less than they could really be entitled to. So, why are you contesting that? If you accept that you breached the contract.
This is because, Mr. Arbitrator, while the quantum of the damages, we are not disputing that the quantum may be higher if they had claimed for their loss of profits. However, this tribunal should not award them damages on a remedy not available under Article 74. Rather, this tribunal should request and follow the standard in typical situations where a substitute contract has been obtained to look at the market price of the wine that the claimants could have sold and take a calculation of damages based on how much losses the claimants can prove. The burden of proof as to damages should always lie with the claimants. And if we were to shift it to look at the respondent's profits, that would not be upholding the principle of full compensation under Article 74 of the CISG. Even if this tribunal were to hold that a disgorgement of profits in this case is available under Article 74, this tribunal should not award it on the facts. The claimants have suggested to this tribunal that their losses here are difficult to quantify. However, this is untrue. Article 74 requires that the claimant need only provide a basis to reasonably estimate its loss, and this was stated by the CISG Advisory Council Opinion number 6.
But if you accept that there's a causal connection, then wouldn't your profit be a basis to assess their loss?
Mr. Arbitrator, the respondents in this case are not suggesting or not accepting that there is a causal relationship. The respondents in this case had multiple customers, of which each of them only obtained 40 to 60% of their order. If all of them were to peg the damages to the profits that the respondent garnered from its sale of wine to super wines, then it would be very difficult for the respondent to structure its relationships. And it is suggested that in our present case, there is no suggestion that that the respondents contracted with super wines in order to get out of its contractual obligations with the
Yeah, but
claimants.
you see, I have a problem with what you're saying about structuring relationships, because you consider the framework agreement is not common in this industry. Your experience in this industry, you chose to enter the framework agreement, so you should be held to what is written in there, right? So regardless of whether you would only have given them 40 or 60% of what you gave to super wines, you've still breached.
Yes, Mr. Arbitrator, the respondents in this case are not suggesting that we did not breach, and we are not suggesting we are not liable for any damages whatsoever to the claimants, but rather that this tribunal should hold the claimants to its legal burden in showing that they have, to reasonable certainty, sustained the loss. And in this case, they are simply trying to circumvent this by saying they want to peg their losses.
Okay, so I asked whether your profits are a measure of their losses. Your response, whether we accept that or not, is that they're not, because their gains would only have been 40 to 60% of what you ended up making. So if we just prorate your profits by 40 to 60% and award that to them as measure of their loss, would you accept that?
No, Mr. Arbitrator, this is because in this case, the respondents are suggesting that there should be no disgorgement of profits, but rather the claimants should be required to prove the loss that they sustained through the conventional methods under Article 74, which requires a calculation as to the contract cover differential between how much the contract between the respondents and claimants costs and how much their substitute contract that they obtained through Vignobilia would have cost. And this is standard market practice as held in the case of in the German Appellate Court of Hamburg. And they stated that where there's a substitute contract that is obtained, this is the iron molybdenum case, they had stated where there's a substitute contract obtained, the damages that a claimant should obtain is merely the difference between what they would have paid if they had contracted with the respondents and what they then subsequently paid through obtaining a substitute. And this should limit the losses that the claimant is seeking from this tribunal.
How do I quantify the loss in that?
Madam Arbitrator, loss of reputation is recognized under the CISG, and there are methods in which the claimant can show their loss of reputation. For example, in the cheese case, again before the German Appellate Court, they had stated.
Which state, sorry?
My apologies.
Which German appellate court?
My apologies. Give me a moment. Of Dusseldorf in that case. And it was stated in that case, the claimant and the respondent were engaged in a cheese selling contract, and the respondent had delivered rotten cheese to the claimant, who then resold it in a very high-end collector's cheese market in Germany. And it was stated by that court that the cheese market in Germany was very volatile, and any malperformance on the part of the respondent or on the part of the supplier would result in backlash by the consumers. And in that circumstance, the damage to the reputation was quantified merely with reference to expert opinion by the Chamber of Commerce. And there was no need to seek a disgorgement of the respondent's profits in that case. The court simply required that the claimant submit to this court expert evidence as to how the effect of its breach on its losses. And that would be sufficient to establish damages under Article 74 of the CISG. There is no corresponding difficulty in quantification. Turning to the element of misconduct on the part of the respondent, in this case, the claimants are suggesting that the respondents in this case had behaved with some level of bad faith when it contracted with Superwines. However, the claimants here have misled this tribunal. The assumed breach from Procedural Order Number 1 was the respondent's refusal to deliver any wine at all, and this occurred in 4th December through a letter that the respondent sent to the claimants. The order that Superwines placed was before this breach of contract in 2nd December, and there should be no corresponding link between these two events. Further to that, the respondents in this case had been talking to Superwines for a substantial time before it had fallen out with the claimants. And in that case, they had discussed the relationship with another major customer of the respondents, Vignicel, and they were in no way trying to target the claimants or trying to undercut them just because they were competitors in the market. And this tribunal should not find correspondingly that there was misconduct where the respondent had breached his contract with the claimant in order to contract with Superwines.
So what's your definition of misconduct here?
Mr. Arbitrator, the claimants in this case are suggesting that this is an element. They are relying on the strengths.
As I recall, you brought up the element, right, in questioning.
They have accepted this element, but the element that we are relying on in this case would be from the commentary to the CISG written by Professor Swenzer and Professor Slectrim. And this area of misconduct is based on the case of Attorney General Blake, which is a UK case before the House of Lords, where a spy had sold confidential information to a newspaper and it got published in the end. And in that case, they had awarded a disgorgement of profits due to the misconduct on the part that the defendant in that case had breached his confidentiality agreement with the government of the United
So a
Kingdom.
breach of an agreement can amount to misconduct.
No, Mr. Arbitrator. Rather, there is some element of a fiduciary duty where the
Is
information.
the fiduciary a concept recognized at the CISG?
Although it is the respondent's position that a disgorgement in general is not available under the CISG, rather these commentaries are suggesting movements in the area of law where this tribunal should take into consideration in adopting a disgorgement of profits.
It's just a simple question. Is the concept of fiduciary recognized in the CISG or in civil law or something of the sort?
Mr. Arbitrator, there is no express recognition of this principle of fiduciary duty.
Well, then that's a problem, right? Because if you peg misconduct to the standard of the fiduciary, but you can't show that the concept of a fiduciary exists in the CISG, then we can't really adopt that definition of misconduct, can we?
Perhaps, Mr. Arbitrator, the respondents are just suggesting an analogous factual scenario where information or documents were entrusted to an individual who then stole these documents and released it to the public against the wishes and against their contractual obligation. Turning to the last issue of evidence that the claimants are seeking for this tribunal to order the respondents to disclose, if I may refer this tribunal to page 9 of the record. My apologies, page 7 of the record. This is the claimant's statement of claim. At paragraph 27, 3rd to 5th line, it reads, the claimant is requesting to order respondent to provide to claimant all documents from the period 1st January 2014 to 14 January 2015, pertaining to communications between respondent and supervised. The respondent in this case, due to the interest of reasonableness, is suggesting or is accepting that this tribunal has jurisdiction to order this document disclosure or has the power to order this document disclosure. Rather, we are suggesting the claimant's request to this tribunal is overly broad and should not be awarded by this
What's the
tribunal.
end date of the clause in your agreement? Clause 20.
Madam Arbitrator, clause 20 says no discovery shall be allowed. However, in the interest of expediency and being reasonable in the present case, we understand the claimant needs documents to prove their case. However, in this case, the respondent is only contesting that the way they have framed their claim to this tribunal is overly wide and is simply a fishing expedition for the respondent's documents.
Yeah, I understand that. It's just I need a standard to determine whether it's broad or narrow, right? So I'm asking whether the contract and interpreting the clause would give me some indication.
My apologies, Madam Arbitrator. Both parties have agreed that the IVA standard rules shall apply in determining what is sufficiently narrow and specific as to a request for document disclosure. And in this case, the respondents are suggesting that this wide frame of time that the claimants are seeking from this tribunal is simply beyond narrow and specific. This is 1.5 years worth of documents that they are requesting from the respondents. Further, we already understand that the claimants knew from page 5 of their statement of claim that the contract only occurred, or negotiations for this contract only occurred in summer 2014, while they are requesting documents as early as January 2014. And there is no reason why the claimant needs to frame their claim for document disclosure so wide. Members of the tribunal,
Can this be compensated by costs if it turns out that they have asked for an undue number of documents? What is the prejudice that you will suffer that is not compensable by costs?
Mr. President, I see that my time has run out. If I could just answer your question. In this case, the damage that the respondent would suffer if this wide ambit of negotiations is ordered by this tribunal would be the damage to his relationship with supervised, and that may not be something that the respondents are able to quantify with mere damages. And in this case, we are suggesting to this tribunal that due to the implied understanding of confidentiality in the negotiations between the respondents and supervised, this tribunal should not order the disclosure of these documents. And if I may be of no further assistance.
Sorry, just one last question. You said that we should not order the disclosure of documents because they are confidential documents. So is that a different line of attack from the ambit of the clause, or are they the same thing?
Mr. Arbitrator, there are more than one requirements when a particular party submits to a tribunal for a request of disclosure. First would be that it's sufficiently narrow and specific. These are all according to the IVA rules. Second, that it's material to the claim that the claimant is seeking or the relevant party is seeking to prove. And lastly, that there will be no issue of confidentiality. While the claimant in this case has suggested to this tribunal several ways in which you can protect confidentiality, the confidential information the respondents are seeking to protect in this case is the number of bottles and the premium that the supervisors had paid. Even if this tribunal were to redact the relevant information, the claimants could simply divide the sum that this tribunal eventually awards them to derive the sum in which supervisors paid to the respondent. And this will not effectively protect the confidentiality between supervisors and the respondent.
So you're saying no disclosure at all? Because if that's the case, then I mean those will be the correspondence in 2015, right? And you're saying that the discovery order should be narrow and specific. So in that case, wouldn't that information be disclosed anyway?
Members of the tribunal, if that information, this tribunal deems that the information is more important than the confidentiality between the parties, then this tribunal has the power to continue and award and require the respondent to disclose his documents. But the respondent is trying to canvass arguments that there is sufficient weight to be given to the confidentiality between supervisors and the respondent, that this tribunal should consider in determining whether they should exercise their discretion in ordering document disclosure. If I may be of no further assistance, that concludes my submission.
Members of the tribunal, two quick points in rebuttal. First, Mr. Arbitrator earlier queried whether our loss would be higher than their profits. At page 55, paragraph 17 of the record, it is clarified that it is very likely that my client's loss would be higher than the respondent's profits. Page 55. And second, there is indeed a causal connection between the profits that the respondent made from his loss and the loss suffered by my client. Now at page 57 of the record, paragraph 27, the first line of the page on 57, it states, equally taking into account the contract subsequently conducted with the long-standing customers, the respondent would have been able to allocate 10,000 bottles to the claimant in June 2015 had it not concluded the contract with Superwise. And these are two reasons why we say there is a causal connection, why we are making a claim for the profits the respondent made in his deal with Superwise. If there is no further questions, this concludes my rebuttals.
Thank you.
Thank you.
Members of the tribunal, 2 points to make in rebuttal. First, pointing to the same page 55 at paragraph 17 that the claimant has cited. While it may be stated there that it is very likely that their profits will have exceeded the profits that they are disgorging from the respondents, the next line states, however, in light of Superwine's strategic decision to become within a very short time the main supplier of high-end wines, it cannot be excluded that they paid a very high premium. There is a tangible risk that there will be overcompensation to the claimant if a disgorgement of profits is permissible or is ordered in the present facts. Turning to the second issue of a causal relation, the claimants have misrepresented the respondent's case. It is not merely upon this causal relationship that a disgorgement of profits should be awarded, but rather, this tribunal should consider that losses defying Article 74 of the CISG, and further to that, their loss must be difficult to quantify, both of which the claimants have not shown. If I may be of no further assistance, this concludes my rebuttal.
Members of the tribunal. My name is Niqian, and I am the second counsel for the claimant, Kaihari Weiner. I will be speaking for 12 minutes, and I respectfully reserve 1 additional minute for rebuttal. Members of the tribunal, in light of the respondent's refusal to deliver any bottle of the 2014 vintage to the claimant obtained an interim injunction from the Mediterranean High Court. The respondent then applied for a declaration of non-liability, which the claimant was forced to defend. The Mediterranean High Court eventually denied jurisdiction due to an arbitration clause in the contract. The central issue before this tribunal is whether the claimant should be compensated for the monetary loss it has suffered in hiring attorneys for these 2 proceedings. The attorney's fees total €50,280, and the claimant has 2 submissions to make in this regard. First, that the attorney's fees incurred are in principle claimable under Article 74 of the CISG. Second, that the attorney's fees incurred satisfy the requirements of foreseeability and mitigation. Turning now to my first submission, that the attorney's fees incurred are a type of incidental loss claimable under Article 74. Article 74 of the CISG states that damages for the breach of contract by one party consist of a sum equal to the loss suffered by the other party as a consequence of the breach. Article 74 is notably very broadly phrased and encompasses costs incurred in the pursuit of one's legal rights. Although attorney's fees are not specifically mentioned under Article 74, where there is ambiguity, Article 7.2 of the CISG points to the general principles of the Convention.
I have a slightly more fundamental question. No matter how Article 74 is raised, you can't run away from the fact that the CISG governs the sale of goods, and a contract for legal services doesn't sound like a sale of goods, it sounds like a sale of services.
Yes, Mr. Arbitrator. However, these attorney's fees incurred were damages that were incurred as a result of a breach of a sales contract. And these are monetary losses, and they fall under the ambit of the CISG.
Aren't costs and damages in principle different?
Madam Arbitrator, we are saying that we are asking for, that is precisely our case, that we are asking here for an award of damages. We are not asking this tribunal for costs. These attorney's fees were incurred in the Mediterranean High Court. In the Mediterranean High Court, under Mediterranean procedural law, each party is to bear its own costs. Therefore, the claimant is asking for the attorney's fees before this tribunal as damages under Article 74.
Wouldn't that be interfering with court's cost order?
Madam Arbitrator, we say that in order for the doctrine of what is known in the common law as res judicata to apply, the International Law Association in its 2004 report has noted that three criteria must be satisfied. So these three criteria are the criteria of same subject matter, same legal grounds, and same parties. And it is not in dispute that the third criteria, same parties, is satisfied, but the other two criteria are not. First, the subject matter before the Mediterranean High Court is not the subject matter before this tribunal. The Mediterranean Code of Procedure applied by default, and the Mediterranean High Court did not hear any arguments on the merits. It did not have an opportunity to examine the reasonableness of the claimant's application for an interim injunction. Second, the legal grounds on which the Mediterranean High Court made its ruling are not the same legal grounds on which we are requesting this tribunal to make its decision. The legal test applied to the question of whether costs can be claimed is to ask whether the claim was frivolous or brought in bad faith. But the legal test applied to the question of whether damages can be claimed is to ask whether the loss was foreseeable and mitigated. And if this tribunal's concern is that awarding the claimant attorney's fees would impinge upon the jurisdiction of the Mediterranean High Court, this concern is addressed at page 17 of the record. Here it is stated, in the judgment on the declaration proceedings, that the court lacks jurisdiction due to the existence of an arbitration clause. Hence, the Mediterranean High Court itself has admitted that this tribunal is the body with the jurisdiction to adjudicate on all claims arising out of a breach of the framework agreement. Returning to my submissions.
So just to check, so you went to the Mediterranean courts to apply for interim relief, and they found that they had no jurisdiction. Not the case, right?
Mr. Arbitrator, there were two proceedings. The first set of proceedings was an application for an interim injunction brought by the claimant. The second set of proceedings was a declaration of non-liability brought by the respondent, which the claimant was forced to defend. The claimant incurred attorney's fees in both of these proceedings, which we are now seeking to claim before this tribunal.
Can I check? So, can I award costs for this proceeding?
Madam Arbitrator, the cost for these proceedings will not be awarded under Article 74. Instead, they will be awarded under Articles 37 and 44 of the VIS rules.
So why is this different? Isn't this a result of their breach as well?
Madam Arbitrator, that is because the VIS rules govern the present proceedings, whereas Article 74 governs the attorney's fees incurred in a prior set of legal proceedings in a different. Madam Arbitrator, the current case law on attorney's fees under Article 74, as stated in the locus classicus, the case of Zapata Hermanos against Hearthside Banking, is that attorney's fees incurred in the present proceedings cannot be claimed under Article 74. However, we are saying that our claim is for attorney's fees incurred in prior proceedings, and therefore such a request will not contradict the decision of Zapata Hermanos against Hearthside Banking.
Does the decision support your argument?
Madam Arbitrator, in the Zapata Hermanos case itself, Judge Posner mentioned that at page 388 that certain pre-litigation legal expenditures would probably be covered as incidental damages, and further commentators such as Dr. Naishmit Ahrens has recognized that an award of attorney's fees incurred in a prior proceeding will not contradict the holdings of Pater Hermanus.
I mean, it doesn't contradict. There are all these statements that say it doesn't contradict or it doesn't prohibit, but I don't quite see how it follows that attorney's fees from a previous proceeding magically become damages instead of costs.
Indeed, Mr. Arbitrator, in Dr. Schmidt-Aaron's work itself, he was writing on the CISG and arbitration, and he was saying that in an arbitration proceeding, it is possible for an aggrieved party to claim for the attorney's fees that it had incurred in prior proceedings as damages under Article 74. And we say that such a result is necessary because
Why? What's the principle behind it?
the principle behind this is the principle of full compensation underpinning Article 74. The principle of full compensation mandates that damages can be claimed as long as the loss would not have been incurred if the contract was duly performed. And even in the CISG Advisory Council Opinion Number 6, it was mentioned that the main limiting factors as to what is or is not recoverable under Article 74 are foreseeability and mitigation. For this reason, learned commentators such as Bruno Zeller, Birgit Pilz, and John Fuller-Magath have argued that in light of the principle of full compensation, attorney's fees such as what we are claiming here, since they are a form of tangible monetary loss, should be allowed under Article 74. And claims for attorney's fees under Article 74 have been allowed by the German Appellate Court in the Shoes case and the stolen car case, as well as the CTEC in the nickel plating production line and chrome plating production line cases.
What if I find that the injunction shouldn't have been granted?
Madam Arbitrator, the respondent will indeed argue that perhaps the claimant's application for an injunction was unnecessary since the respondent had not even bottled the wine at the time the injunction was obtained. But in fact, the Mediterranean High Court had granted the injunction on the basis that it was necessary at that point in time. And we say that
Am I entitled to disagree with that opinion?
Because surely if we are entitled to re-decide who bears the cost, and I use this in the colloquial sense, the cost of the proceedings, we are also entitled to look at the reasoning behind it again, right?
Anyway, it's interim, right? So I guess if I find otherwise, then what happens to your argument of cost?
members of the tribunal, we are saying that in asking for our attorney's fees, we are not requesting this tribunal to relook the decision of the Mediterranean High Court. And in fact, the International Law Association has written that in the common law, procedural decisions cannot give rise to a plea of issue estoppel, and in the civil law...
My concern is small. Where do we draw the line? Because what happens if, let's say, you, the claimants, go to 10 other jurisdictions, take out 10 other successful applications, get a worldwide marine law and respondents, do all kinds of things, win on all of them somehow, and then come here and say, we've lost all this money in terms of legal costs? That doesn't sound very reasonable to me, right? So where do we draw the line?
Mr. Arbitrator, perhaps the reasonableness will be assessed under foreseeability and mitigation, which are limiting factors under Article 74. So if indeed we had gone around the world to obtain Mariva injunctions that would not have been foreseen at the time of contracting, foreseen by the respondent at the time of contracting, neither would it have constituted a reasonable mitigatory measure.
Fair enough. Then wouldn't that lend strength to the argument that you propose they might make, which is that the wine would only have been bottled a few months later, so they couldn't have foreseen on that basis that an interim injunction would be granted now, right?
Mr. Arbitrator, we say that if this tribunal will turn with me to page 16 of the record, we see here that the injunction would prevent the respondent from selling or committing for sale any number of bottles of wine that would prevent it from supplying 10,000 bottles to the claimant. And we see here that the key concern of the claimant is not strictly the delivery of the bottled wine, but the subsequent contracts of sale that the respondent might enter into. At that point in time, the respondent's award-winning wine was clearly well sought after. Hence, it was reasonable for the claimant to secure the 10,000 bottles should the respondent choose to enter into further contracts that would prevent it from supplying 10,000 bottles to the claimant.
So the merits of the application don't matter as long as it was a reasonable progression. Is it like, let's say I find that you have been adequately compensated by damages, so the injunction was not necessary. If I come to that finding, do I still have to give you damages for that?
Madam I see that my time is up. If I may respond to this question. Perhaps if this tribunal finds that the claimant is adequately compensated, then perhaps it would say that the attorney's fees incurred were not foreseeable or that it was not a reasonable mitigatory measure. But we say that the losses that we incurred as a result of applying for the interim injunction are losses that must be compensated in order for the claimant to be made whole. And we urge this tribunal to fine for the claimant.
What do you say? Can you remind me what are the two limiting factors again?
Foreseeability and mitigation.
You see, those would make sense for damages, right, rather than costs. So that's one. Secondly, the purpose of cost is not compensation, but for damages. So you seem to be wanting to have a case.
Mr. Arbitrator, we are saying that our claim for the attorney's fees incurred is a claim for damages because it is a tangible monetary loss that the claimant would not have suffered if the respondent had not breached the framework
I
agreement in
understand
the
that,
first
but
place.
under conventional understanding of cost, you are expected to lose something, right? You have no expectation to be compensated, unless you're saying under international arbitration, principle of that. In other words, you never get full indemnity. You only be partially reimbursed. So why should it be our business to try to compensate you? And that is the realm of damages.
Indeed, Mr. Arbitrator, our argument is that the claimant at that point in time was forced to obtain the interim injunction because there was no other course of action that it could have taken.
I think we understand that argument. If I'm not misreading Mr. Arbitrator's question, it's just that the two are conceptually different, right? Costs will always leave you with some sort of shortfall. On the other hand, damages are compensatory, and Article 74 even says there's a principle of full compensation, or at least it's somewhere inherent in the article. So how do you reconcile the difference between the two?
Mr. Arbitrator, we are members of the tribunal. We are simply asking for the sum that we incurred in hiring attorneys for these two proceedings before this tribunal. We are not asking this tribunal for an award of costs. That will be governed by the VIS rules. If this tribunal has no further questions, this concludes my submission.
Just one question. Why do you keep citing the ILA?
Madam Arbitrator, because it vote on the topic of res judicata in international arbitration.
So is it
And
law? Like, what clause does it have?
it examined the current position under common and civil law countries, as well as how res judicata is typically understood in international arbitration. It does not have the force of law, however, it is a summary of the current legal position in common and civil law countries, as well as in international arbitration. This concludes my submission. Thank you.
Members of the tribunal, good evening. My name is Jeremy Tan, and I speak here on behalf of the respondent in respect of the third and final issue before this tribunal, which is the issue of the claimant's costs incurred in the prior sets of proceedings. I'll speak for 13 minutes and respectfully reserve a further 1 minute for my rebuttals. Now, before I turn to my submissions proper, I would first like to address the tribunal on one of the key issues regarding this matter, which is this notion of the scope and the delimitations of this tribunal's jurisdiction. It is common ground between the parties that the costs the claimant are seeking have already been decided upon by a court of competent jurisdiction, the Mediterranean High Court. And the claimant now seeks to reopen the very same issue before this tribunal and claim the exact same sums by recharacterizing them as damages under the CISG. This we say they cannot do, because what has not changed is that the sums in question are the exact same sums the Mediterranean High Court has already decided upon.
That's true, but doesn't one follow from the other? Because the fact that the Mediterranean High Court ordered claimant to bear those costs turned those costs into an additional part of the loss which the claimant suffered. So then they would become losses that that the claimants are compensable for under Article 74 would it be?
Mr. Arbitrator, we say that this isn't the proper characterization of the cost because that in the established scholarship under the CISG, the position is that these attorneys' fees or attorneys' fees generally do not form a part of the losses that are considered losses flowing from a breach of contract. Even if we were to say that they weren't, there would still be the question of this interference with the Mediterranean High Court's jurisdiction.
Sorry,
And
can I take you back? Why is it that attorneys' fees wouldn't form part of the loss?
Mr. Arbitrator, if I could direct you to the authorities on that then. It is true that the CISG and the accompanying Trevor are silent on the matter of the attorneys' fees, but the dominant scholarship in the area, in particular the CISG Advisory Council number 6 and the Court of Appeal case from the United States of Zapata, Hermanos and Herside Baking, say that it is common ground that attorneys' fees are not a part of damages under Article 74 and they should be decided rather with reference to the applicable procedural rules. Now there are a number of policy reasons for this, but one of the largest is that the various member states of the CISG all have differing and competing approaches to the question of costs and decide them as costs or damages differently. Accordingly, they say that attorneys' fees do not fall within the CISG scope and should be determined with reference.
Just because different countries and courts decide this differently.
There's also the principle of equality. But let's address first the question of the different member states. In particular, in the case of Zapata Hermanos and Herside Baking, then Judge Posner of the U.S. Court of Appeal noted that because all the different jurisdictions come in with their differing cost rules, for example, the Americans with their American rule of each party bears its own costs, and other civil law jurisdictions which have a loser pay system, they said that if the CISG had been interpreted as overriding all of these differing approaches, the United States would never have signed on to the CISG. And in that case, they said that therefore attorneys' fees should be regarded as outside the CISG scope. The second line of reasoning, this one in principle, is that awarding such fees would conflict with the principle of equality and it would lead to unequal treatment of claimants and respondents under the convention. Now, the typical procedure for attorneys' fees is that both parties may make submissions as to how costs should be ordered, and then the tribunal or court designated would decide. But if the CISG is taken to include claims for legal costs, then these claims would be dependent upon there being a provable breach. Successful claimants would be able to seek their costs incurred in prior proceedings or before the main litigation, but successful respondents who might not have counterclaims would be left unable to prove a breach and be compensated for their loss. This means that respondents would then be unable to claim their costs and would be treated unequally by the convention.
Could we not imply some sort of legal fiction into all this, like say that claimant who brought a claim that failed and therefore should never have been brought has reached some sort of term of good faith and we can give you costs for that?
Mr. Arbitrator, it is true that some commentaries have indeed made this exact same suggestion. However, we say that this would be a difficult proposition. This would be difficult to serve as a ward against overreach because in not every instance would it be possible for the successful respondent to prove bad faith, which is a very high threshold indeed on the part of the claimant in that case. So we say that this is not a sufficient stopgap. And indeed, this ties in with the broader overreach that the claimant is making. The principle of in their conception, they say that attorneys' fees are awardable simply on the basis of this principle of full compensation. But if we take that principle to its logical conclusion, nothing they have said would prevent them from claiming the cost in these proceedings from being claimed under Article 74 of the CISG.
But that's because the VIS rules provide for different optional costs, right?
Well, Madam Arbitrator, if we were to apply that logic as well, in this situation, there has also been another procedural law that governs the question of the cost that they are seeking, and that is the Mediterranean Code of Procedure.
Yeah, but I don't have, as in, I have jurisdiction over costs in this arbitration, right, provided by the rules.
Yes, madam.
That's quite different from the situation where costs have been awarded by court and they are now seeking that as damages. I think they are quite different situations.
Yes, Madam Arbitrator. But in either case, the distinction or the delimit that they are trying to draw doesn't work, because they are saying that if we follow that logic, the costs in the present proceedings cannot be claimed because there's applicable procedural rules, but the costs in prior proceedings, there's nothing to say that they cannot recharacterize the costs in these present proceedings also as damages and therefore circumvent the procedural rules.
Is there really nothing? Wouldn't the procedural rules themselves be the thing that prevents that, because that would be parties' agreement? So in a sense, they've agreed to have it decided this way, and they can't now go and recharacterize things.
Well, Mr. Arbitrator, we would say that the same logic applies in respect of the prior proceedings, in that the claimant has agreed or took the option of seeking the injunction in that form and thereby agreed to those procedural rules. So to allow it to get out of those procedural rules by claiming them as damages, that logic should also equally apply to the present proceedings.
Well, I suppose the claimant would say that there wasn't an agreement there. In fact, there was a disagreement, and as a result of that, they were forced to take the action that they did.
Well, Mr. Arbitrator, perhaps we can turn to the next submission then, if the tribunal is not with me on this, which is, or rather, to turn to my submissions proper. I have two further submissions to make, the first of which applies to both sets of proceedings, and that is that the costs incurred in both sets of proceedings were unforeseeable in their extent. My second submission, which relates to the declaratory proceedings in particular, is that the claimant is precluded from claiming these costs because its conduct led to the breach. Turning to the first submission on foreseeability, we say that even if this tribunal regards attorney's fees as awardable under Article 74 of the CISG, this tribunal should only award the claimant nominal damages because the bulk of the fees claimed were not foreseeable. Under Article 74 and under the principle of foreseeability, in order for a claim for damages to succeed, the defendant must have reasonably foreseen at the time of contracting, here that would be in 2009, the type and extent of loss suffered. If the tribunal would turn with me to page 19 of the record, this is the invoice from the claimant's lawyers from the earlier proceedings. And if you'll examine that page, you'll see that there are hourly charges for work, and that these charges total roughly about $5,000 and thereabouts. The bulk of the fees being claimed by the claimant are in fact the contingency fee, which is the second last line, sum of $45,000. Now, while it might be fair to say that it was foreseeable, of course, that the claimant would incur legal costs in the event of a dispute, what we say was not foreseeable was the fact that the claimant would incur costs of this extent, and in particular use a contingency fee. At the time of the contract, the claimant had liquidated assets it could use.
Hold on a second. Are you disputing the quantum of the bill, or are you disputing the mode of calculation? That is, are you disputing that their use of contingency fees was fair or unfair?
In respect of that, Mr. Arbitrator, our main dispute is that the contingency fees were unreasonable and were not reasonably foreseeable at the time of the contract.
Why is it that the measure of contingency fees automatically makes something unforeseeable? What about a very unreasonable hourly rate or very reasonable contingency fee?
Apologies, Mr. Arbitrator, I misunderstood your earlier point. It is indeed the quantum, and in particular, we are saying that the extent of the claimant's claim is unforeseeable. The extent is very high in the present circumstances, in large
So
part
you're disputing
because of
the
the
pure
contingency.
number, and you are not disputing the use of contingency fees.
Mr. Arbitrator, we say that the contingency fee is a relevant aspect of that. At the time of the contract, the claimant had sufficient financial assets and was in no apparent financial difficulty. But at the time of the dispute, the claimant's assets were tied up in various investments. At page 58 of the record, paragraph 38. There it states that the claimant was acquiring a printing house specializing in printing etiquettes for wine. And in the next sentence, it states that the investment bound up all of the claimant's liquid financial resources. So we say that while we could have, of course, predicted that the claimant would would incur legal costs, we could not have predicted that they would be unable to secure lawyers on the normal hourly fee basis and would have to resort to a contingency fee, thus artificially inflating the extent of their costs.
So you guys are, the respondents are from which of the states again?
We are from Mediterranean.
But it says down here on the same page that contingency fees in Mediterranean are fairly common. So even if the claimants had an option, it wouldn't have been uncommon for them to still go by contingency fee, would it?
Well, Mr. Arbitrator, in respect of that, we say that in the claimant's home jurisdiction, contingency fees were in fact prohibited, which is stated in the same paragraph Mr. Arbitrator just read from. We say therefore that in light of all the facts, we could not have predicted or reasonably foresaw that they would resort to a contingency fee.
But I mean, okay, if you wanted an injunction to stop you, of course they'll come and get it within your state, right? So how is it not foreseeable?
Madam Arbitrator, our first position is not so much the jurisdiction, but rather that there was no reason at the time of contracting that was apparent to us that they would need to
You
resort to.
contracted for arbitration, didn't you?
Yes, Mr.
You
Arbitrator.
contracted for arbitration in a country where contingency fees were permitted. Surely you would have thought that they retained counsel who could have charged contingency fees.
Well, Mr. Arbitrator, in response, if I could perhaps direct you to a decision by this very same tribunal, an unpublished VIS decision, where they considered the question of contingency fees or success fees. And there they said, they decided that the success fee or contingency fee was not part of the reasonable cost incurred by a party in bringing its case, because the initial submissions, of course, were already covered by hourly fees, which is the same position as we see here, that in fact the work done has already been charged in the form of hourly fees, and that the contingency fee that forms the bulk of the claimant's cost is in essence a success fee.
I'm not sure I followed that reasoning, because the hourly fees here were remarkably low. We're talking $150 an hour sort of hourly fees. That really is quite low. So couldn't it be that they were this low because there was going to be a contingency fee, and it's the sum total of the two that was the reasonably low fee?
Well, Mr. Arbitrator, if I could direct you to page 58, paragraph 39, there is an explanation on the facts for the low sum given for the hourly fee. At the 7th and 8th lines, it says, though the contingency fee would ordinarily be reasonable, in the present case, less time was spent due to the uncontested or the short nature of the proceedings, and as a result, the fees being claimed are far higher than they would ordinarily have been. Members of the tribunal, I see that my time is up.
Can I clarify, is reasonableness one of those or
Yes.
foreseeability?
Members of the tribunal, in the interest of time, if I could just have another 2 minutes to finish my final submission.
Take one.
Much obliged, Mr. Arbitrator. My final submission is that the claimant is precluded from claiming the cost in respect of the declaratory proceedings because its conduct led to the breach. And this is because of the operation of Article 80, which states that the party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. There are 3 facts that the tribunal should take into account in assessing this. The first is that the arbitration clause before the parties in the contract appeared pathological. This clause can be found at page 9, but the defect in particular is that the clause referred to a non-existent arbitration tribunal, the International Arbitration Tribunal. The second fact is that the claimant sought and obtained an interim injunction in Mediterranean's High Court. This, in addition to being in respondent's view a breach of the contract stipulation to settle disputes amicably, also enhanced concerns over the validity of the arbitration clause. Now, after obtaining the interim injunction, the claimant did not, as we would have expected, seek to clarify or settle the dispute or resolve it or make the injunction permanent. Instead, it did nothing. And in order to clarify if the arbitration agreement was still afoot, the respondent sent a letter on 14th January, which can be found at page 33, seeking to clarify if the arbitration agreement was valid. The claimant, however, did not respond, and it was because of its omission to do so that we brought the application for the declaration of liability in order to resolve the dispute. So we say that their failure to clarify if the arbitration agreement was afoot and their bringing of the interim injunction were breaches of the duty to cooperate under arbitration, which therefore caused the respondent's breach of the arbitration clause. And accordingly, under Article 80 of the CISG, we say that their breach prevents them from finding us from asserting our liability. If the tribunal has no further questions, that concludes my submissions.
Thank you. Maybe the claimants can address that last point in its rebuttal. Your choice, please.
Members of the tribunal, I have one point to make in rebuttal. The respondent has asserted that Article 20 of the Framework Agreement was not clear. However, if this tribunal will turn with me to page 9 of the record. If we look at Article 20, it states that if no agreement can be reached, the dispute shall be settled by arbitration in vinda bona by the International Arbitration Tribunal under its international arbitration rules in accordance with international practice. There is only one international arbitration tribunal in vinda bona, and we say that surely the claimant cannot assert that this clause was not clear. In addition,
When did that international tribunal in vinda bona come into existence?
Mr. Arbitrator, it is not stated on the facts. However, if we turn to page 60 of the record, paragraph 55, it is stated here that the VIAC is the only international institution which operates in vinda bona. And it is clear that since the parties have an arbitration clause with the initials of VIAC, it is clear that this refers to the only arbitration institution in vinda bona. In addition, we say that a mere failure to reply to a letter surely cannot meet the standard of causation under Article 80 of the CISG, and it cannot allow the respondent to escape liability for a clear breach of contract. If this tribunal has no further questions, this concludes my rebuttal. Thank you.
Members of the tribunal, I have but one point to make in rebuttal. The tribunal should remember that it has to take all of the facts in totality. But even taking this particular fact of the defect in the arbitration clause, there is case law to suggest that the respondent's concerns were well-founded. In a 1994 decision by the German Appellate Court of Hamm, they considered the validity of an arbitration clause which referenced a non-existent arbitral institution. There, the contract was governed by Swiss law, but referred all disputes to the Court of Arbitration of the International Chamber of Commerce in Paris at the Sea of Zurich. And the Oberlandesgericht then stated that the arbitration agreement would be invalid on the basis that it was ambiguous, since that institution stated did not exist. Accordingly, we say that it was a well-founded concern of the respondent that the arbitration agreement might not be valid.
I'm pretty sure that 20 years after 1994, the modern law jurisdiction has moved towards enforcing logical clauses, and that the error in the clause is not extremely effective. So I'm not sure the objection is.
Madam Arbitrator, we do accept that the law has changed in this area. However, we say that it was still reasonable for us to seek clarification, and that it is unreasonable for the claimant to persist in seeking to hold us liable when they could have avoided this entire matter simply by clarifying and responding to our letter.
Sorry, but you haven't pleaded estoppel or anything similar or analogous to that.
Mr. Arbitrator, it is actually accepted in the scholarship on the matter that the principle of estoppel is encapsulated in Article 80 of the CISG, upon which we rely. However, the test is somewhat different.
Thank you.
further questions? That concludes my submission.